So I'm Marshall Turner. I'm going to do the first half of the presentation. Caleb's going to do the second half of the presentation. We're both in the insolvency department. I do a broad range of primarily creditor representations, although I do debtor work once in a while, and I like to do debtor work. Caleb also does kind of the same, probably more, more of a creditor representation with an emphasis on representing landlords and mall owners in large retail bankruptcy cases. And I'll let him provide a little more background on his specialties when it's his turn to present. So with that, I think we'll start. And as far as just general creditor representations, we'll talk mostly about executory contracts and leases. But if you have a client that is in any way, shape, or form involved in a situation where a counterparty either is in bankruptcy, is in some sort of a state court receivership, an assignment for the benefit of creditors, or is just generally not in good financial situation, please contact somebody in the insolvency department. It can be myself, it can be Caleb. There's probably another 15 or 20 folks that have got really strong experience in representing creditors. And I think the earlier the contact is made, the better the representation of the client can be. And even if we're not specifically engaged to represent the creditor in that matter, give us a holler. We'll give you a couple free minutes, give you some ideas, and you can use that information to pitch the client on maybe some issues that they're not aware of, for which they will need our services in the future. So I think the earlier you get a hold of us in connection with anything where your clients are dealing with a counterparty who is experiencing financial distress, the better information we can provide you, the better representation we can have for the client. So some really, really basic stuff. When a debtor files for bankruptcy, they will at some point, either immediately upon filing the case or usually shortly thereafter, they'll file their schedules. The schedules list, among other things, all of their creditors and what the debtor asserts they owe those creditors. Those schedules may be right, they may be wrong, they may be incomplete. So irrespective of whether or not your client shows up on those schedules, you need to really think about filing a proof of claim. It is much better to file a proof of claim, even if the schedule accurately reflects the amount that is owed to your client, indicates that it's not contingent, it's not subject to dispute. The debtor can always change their schedules right up to the end of the case. And so it is advisable to file a proof of claim, asserting the correct claim, and to ensure that it is filed before the proof of claim bar date. In most cases, the proof of claim bar date will be on at least 60 days notice to creditors, sometimes 90. I think we're seeing these days that a lot of debtors counsel in larger cases are being pretty aggressive on getting the bar date set early in the case. So it's really important to pay attention to that and to be in tune, because once that bar date passes, if the claim hasn't been filed, you're 99.99% out of luck, barring some sort of excusable neglect, and which is a very, very hard burden to prove. It's not fun trying to prove it either. So got to pay attention to that. And then the primary things to be aware of when you're preparing a proof of claim, and we're glad to assist in that. In fact, I think it is advantageous to give us a quick shout on that as well. Is the claim a secured claim? What is it secured by? What's the value of the claim? Is it an unsecured claim? What's the basis for the claim? And we've got a addendum that we attach on all proofs of claim, which describes the claim in detail, and then it's got a set of reservations of rights, that you're not waiving your right to a jury trial, that you're not waiving your right to further amend the claim, et cetera, et cetera. And those should be part of any proof of claim that is filed. An additional thing to pay attention to is, to the extent your client has delivered goods within 20 days of the bankruptcy filing, your client's most likely entitled to an administrative expense claim for those goods. That is, even though they may not have been paid for prior to the bankruptcy being filed, you as a matter of law can get paid during the case or 100% in cash on the effective date of the plan. So with regards to claims that are 503b9 claims, goods delivered within 20 days, your client should be in good shape, but you want to pay attention to any specific 503b9 bar dates, and you want to be able to assert your claim there and get it paid. Sometimes you can get it paid earlier than confirmation of the plan, but typically debtors are resistant to part with their cash until the end of the case. One thing I don't have on the slide there, also be in tune for, and here it can make the difference between receiving 100 cents on your claim and 0 are secret liens. And so every state has got, well, I don't know about every state, but a bunch of states have got different statutes dealing with liens that won't necessarily appear, at least initially, on a Article 9 UCC 1 financing statement. Those liens can be, for example, in Illinois, there's a whole bunch of liens for suppliers of grain, farm crops, inputs into farms. There are secret liens for people who are mold makers. You've got mechanics lien statutes in all the states. And so Caleb and I have dealt with this on a couple of cases where our clients don't have a grant of security interest, don't appear to be a secured creditor, but because of their peculiar status and the fact that they are protected under state statutes, it turns out that they do in fact have fully secured claims, and that literally has been the result in getting paid 100 cents on the dollar versus, in some cases, 20 cents or less. So that's important to pay attention to, and again, that's different state by state and may require a little bit of research. All right, moving on to executory contracts. So executory contracts are governed by Section 365 of the Bankruptcy Code. And just a couple pages of the code, a whole bunch of stuff going on in there. We're going to deal primarily with the basics and a little bit of esoteric things. First off, what is an executory contract? The classic definition of an executory contract is called the Countryman definition. And basically it's a contract where if any party, either party to the contract breached it, they can materially breach the contract. And so we'll use, for purposes of the next few slides, let's just pretend MTC Washington Corporation has a contract with a debtor. It's a 12-month contract. Once a month, MTC Corp goes over and washes the windows for $100. That, assuming that the debtor files in the midst of that contract, so let's call it 6 months within the contract, that clearly would be a executory contract. That is, if I decide that I'm not going to show up and wash the windows, that's a material breach of the contract. And if the debtor decides that, notwithstanding the fact that I've gone and shown up and washed the windows, the debtor is not going to pay for that, that's also a material breach. So it's an executory contract, really simple form of contract. Most contracts, it's pretty easy to tell. Sometimes there are some issues. There can be some issues, and we'll talk about this in a second with regards to invoices. Sometimes there might be a master contract that governs the invoice terms, and there may be a question that arises as to whether or not that makes it executory or not. We can deal with that. An important protection for debtors in 365 is Section 365E1. And this is, in bankruptcy parlance, called the ipso facto prohibition. A provision in a contract that says that the non-debtor counterparty can terminate the contract on account of insolvency, the financial condition of the debtor, the commencement of a bankruptcy case, or the appointment of a trustee in a bankruptcy case are just not enforceable. So if you're in a bankruptcy, you look to your contract and say, oh, I've got all these outs. You don't. They're not enforceable. And to the extent that the contract is an executory contract, the debtor is going to have its protections set forth in 365 and otherwise in the Bankruptcy Code to make decisions as to whether or not to assume or reject that contract. Before we get into assumption or rejection, we'll talk real quick about some clearly non-executory types of agreements. The easiest is just an invoice basis. If on a service or delivery of good basis, I'm just doing it on an open invoice. There's no master contract governing it. There's no requirements contract. Each of those invoices is viewed as non-executory. It's just, it's not executory. And as we'll see, the debtor cannot force you to continue to provide them with services or goods if you just have an invoice relationship. That can be important. And it can be important in the sense that to the extent that it is difficult for the debtor to obtain the goods or services that they're getting from you on an invoice basis, and particularly in the larger cases, that may open up some leverage on the part of the non-debtor counterparty to the extent, let's just say, that non-debtor counterparty is owed $500,000, but the debtor really needs the widgets that that non-debtor counterparty is making in order to have a successful reorganization, and either cannot at any cost or cannot within a reasonable cost get those widgets from someone else. Then, in many of the larger cases, the non-debtor counterparty to those invoices could very well say, I will continue to provide you with the product or the good or the services that I was before. However, you must pay me $500,000 cash on the barrelhead before I do so. And most large cases will have an authority to pay critical vendors. And that's where, having a non-executory invoice relationship can be very beneficial. If, on the other hand, you're owed $500,000 and all you're providing is a real, pure commodity widget, likelihood is the debtor is not going to pay you, and the debtor is going to go to somebody else to provide him with those purely commodity type widgets on a post-petition basis. So that can be a double-edged sword. I don't know why I threw this in here. Options. So an option contract where you've paid the premium, where the non-debtor counterparty has paid the premium, or the debtor has, either way, and all that's left to do is the ministerial or administrative act of exercising the option, whether it's a financial option, whether that's an ag option, whatever it is. That is probably not considered to be an executory contract. I looked at this a long, long time ago. I remember there's a little bit of split in the case law on it. There's also other provisions of the Bankruptcy Code, safe harbor provisions dealing with swaps, derivatives, forward contracts, options, etc. So if you've got any sort of an option contract, financial or otherwise, with an entity that's in financial distress, definitely reach out to us. There's a lot of stuff to digest with regards to that, and the sooner that you get somebody's, from the insolvency side, eyeballs on it, I think the better off for your client. So why does it matter if it turns out that your client's got an executory contract with a debtor? It matters because the debtor's got two great powers in the Bankruptcy Code under Section 365. The debtor can assume or reject the contract at any time before confirmation of the plan. There are pretty serious economic ramifications to each of those. If the debtor, during the bankruptcy case, decides that it no longer needs the services under that executory contract, it can reject the contract. The effect of rejecting the contract is as if the debtor had materially breached the contract the day before the bankruptcy filing. So as a non-debtor counterparty to a rejected contract, you've got your damages claim under the contract that you can assert against the debtor, and you do that by filing a proof of claim. If for some reason the proof of claim deadline has already passed, you're most likely going to get at least an additional 30 days to file your rejection damage claim once the contract is rejected, because that's done pursuant to an order of the court. So you need to hop on that and get that done within that time frame. And you're going to end up with an unsecured claim for whatever your contract damages are. In most cases, that means that you're going to get pennies on the dollar. So, for example, in the window washing contract, it's a year contract, $100 a month. As of the bankruptcy filing date, they were delinquent. They owed you $300. They paid for 3 months, they hadn't paid for the last 3 months. They filed for bankruptcy. They decide they don't need this contract because they can go to whomever who does a better job. They reject the contract. So now I've got a rejection damage claim for the $300 that they owed me already at the time of filing. I've got a damage claim for the $600 I was expecting to get for the duration of the contract. So $900. I've got a $900 unsecured claim, and just ballparking it, I'm kind of lucky in most cases if I get 10 cents on the dollar. So $90 on a $900 claim. The better result is if for some reason the debtor decides that the services I'm providing are of such high quality or uniqueness that it needs to continue to obtain those services, particular after the time of confirmation of a plan, assuming that the contract has a duration that spans that time period, then it is likely that the debtor is going to make the decision that it's going to assume the contract. For all intents and purposes, if the contract's assumed, it's as if the bankruptcy never happened. To the extent the debtor owed me $300 that it hadn't paid me before filing the bankruptcy, as a matter of law, when it assumes the contract, it has to cure all pre- and post-petition defaults. So the $300 pre-petition default has to be paid in cash at the time of assumption. To the extent that the debtor had been delinquent in post-petition payments, which really shouldn't happen because they're supposed to pay you on a timely basis according to contract terms for services or goods you deliver post-petition. Nevertheless, it does happen that they get in arrears at times. Those have to be cured as well. So again, if the debtor makes a decision, which is an exercise of its business judgment, to assume a contract, then for all intents and purposes, the non-debtor counterparty is taken care of. It's as if the bankruptcy didn't happen, and it tends to be a good result. The other power that the debtor has, which for some non-debtor counterparties can be unnerving, is that notwithstanding the fact that your contract may very explicitly and clearly say that this contract cannot be assigned to a third party without the express written consent of me, that provision is also void. And barring, a few potential defenses that the non-debtor counterparty has, such as lack of adequate assurance of future performance, potentially if the contract's being assigned to a competitor, that would cause some problems. By and large, assumptions and assignments to third parties are effective and do go through, 99, again, my experience is 99.9% of the time. 99.9% of the time, the clients are very happy that that is happening, irrespective that it's being assigned to a third party. And only in some occasions is there some issue with the identity of that third party, such that we have to go in and either try and block it or change the terms and nature of that assignment. There are some exceptions to the debtor's kind of unilateral ability to decide whether to assume or reject a contract within Section 365. One of them there is not 365R, it's 365N, so we'll blame Caleb for not fly-specking that, even though I'm the one who wrote out the slides. 365N is an exception to the general rule that a debtor can reject a contract and that the non-debtor counterparty is basically out of luck. With regards to intellectual property, which under the Bankruptcy Code is defined to include patents and copyrights, but arguably not trademarks, although there appears to be a vibrant set of case law primarily originating out of the Seventh Circuit on it. If the debtor is a licensor and seeks to reject the license, so for example, a software license, let's say the debtor was Microsoft, and there's 500 million licenses out in the world, and it decides that it wants to reject all licenses of Microsoft Office. Under 365N, the non-debtor counterparty has an option. It can either elect to have that treated as a regular rejection of a contract, in which case it's just got a damage claim, or it can elect to continue to obtain the benefits of the license for the duration of the contract, so long as the non-debtor counterparty continues to make the payments required under the license. So that's a big protection for non-debtor licensees, and it is a big exception. There are also exceptions within 365 that deal with shopping center leases and timeshares. I won't go into those in great detail, but if you ever have non-debtor counterparties that are involved in those types of contracts and or leases, there are special rules, and we can help figure those all out for you. So I think that wraps up my quick presentation on executory contracts. I'll turn it over to Caleb on leases.
All right. Hi, everybody. My name is Caleb, and as Marshall will kind of give a brief introduction, I am an associate, formerly I guess, still associated with the Chattanooga office, but I now work from home in Peoria, Illinois. Before it was cool, I was working from home, and now everybody else has joined. And when everyone goes back, I will still be working from home. But it works in bankruptcy, and the clients have been great with it. I joined Marshall's statements in if you run into executory contracts and leases in bankruptcy, there's a lot of nuances that can occur. We have actually set up a little plug, an insolvency task force, that if you run into bankruptcy or insolvency issues, we have attorneys set up that we can direct you to. So if you have a lease issue, you might come to me. If you have a trade vendor issue, you might come to Marshall. If you have, some sort of financial accommodation issue, maybe you go to Daniel Bray. So, if you have clients, this is a great area that we see that folks can bolster with their clients, and clients often have questions and they don't see the needs, and sometimes they can get burned. So just, kind of a quick shout out for the insolvency task force that, we're here to direct your clients to the right attorney to protect their rights. And as you probably are seeing, this insolvency is certainly ticking up with COVID. So my background is I am, from day one, I think when I entered the firm 6 years ago, I was on landlord representations in bankruptcy. So this is kind of something I've done from day one, and now I'm sort of a bankruptcy generalist, but we still have been involved in probably every major retail shopping center case in the past 5 or 6 years through some of our landlord representation. So we have a lot of reps with this stuff. Under 365A, and this came out in 2005, a debtor has 120 days to decide whether it can assume or reject a contract, with one 90-day extension for cause. And cause ends up being pretty loose in this context. So really 210 days from the date they file to decide whether or not they want to assume or reject your unexpired lease. This is important because formerly retail tenants would file bankruptcy and they just sit in bankruptcy sort of indefinitely. And there's some other things that happened in the 2005 amendments to 365. For example, they are supposed to pay timely. Before, you would have to file motions with the court to compel either rejection or compel them to pay in bankruptcy. And it was landlords were getting burned on a pretty regular basis when these tenants were filing. And so now the law is a little bit better, and we have a little bit more leverage. So within 210 days, they have to decide whether they're going to assume or reject the contract. As Marshall described, assumption and rejection. Rejection is a court-authorized material breach of the lease. In the landlord context, the debtor is required to vacate the premises upon rejection. In the context of, say, an equipment lease, the debtor is to turn the equipment back over to the lessor. Damages are limited under the bankruptcy code for lease rejection. And this is important because the reason a lot of these tenants where you see in the news, or you got, Forever 21 filing, JCPenney filing, their leases are burdensome, right? They can't pay for the real estate anymore. When they signed these leases in JCPenney 30 years ago, shopping centers were it, and they could afford to pay, for the 120,000 square foot space, or, probably not that big, but, whatever the case, that they could pay for it. And now they don't have to reach out foot traffic, they can pay for it. So they file bankruptcy and they kind of hold the sword of rejection over the landlords. And they say, if you don't agree to, significant lease modifications, rent reductions, et cetera, we're going to reject your lease. And if they reject your lease, the landlord is limited to damages of 1 year of rent and charges under the lease, or 15% of the remaining term, whichever is greater. And so the 15% doesn't come into play that often. I think that the threshold is somewhere in the 6 to 8 year range. If the lease has that much remaining, then 15% of the term comes into play. So most of the time we see that you get 1 year of rent and charges as your rejection damage claim from a lease. And as Marshall mentioned, those are usually paid out on pennies on the dollar. Those are general unsecured claims. So as you can see, it's a big piece of leverage for these, retail tenants, or, we have trucking companies sometimes file who are, renting their big rigs, things like that. I mean, it's a real big piece of leverage for the debtor. Assumption in the lease context means that the debtor must take the lease as is. You, as the lessor, are not required to make any modifications to that lease. And they have to cure all arrearages, monetary or otherwise. If their insurance lapsed, they have to reinstate that insurance before they can assume the lease. They have to pay all the pre-filing arrearages, any post-filing arrearages. They have to make good on all those. As I kind of described with rejection, these are all deal points. Increasingly, especially in the shopping center context, there's a lot of open spaces, and so tenants are getting things that they haven't gotten before. So waiver of all cure, or a percentage rent deals, things like that. And so these are always deal points. We get contacted sometimes even before a case filing by Hilco, A&G, one of these guys who are the retail brokers, and they come in and they say, to keep these 4 leases of yours, we need this amount of rent reduction, this amount of rent reduction, this amount of rent reduction, and we kind of go from there. The other piece for a lease is they must provide adequate assurance of future performance under the lease. This encompasses, in the lease context, especially shopping center context, some interesting factors. And as Marshall says, sort of in the executory contract space, we're often happy to see a lease assigned to somebody, because they're going to pay arrearages, they're going to keep going. It's as if the bankruptcy never happened. In the shopping center context, we run into some more difficulties. If a grocery store wants the Toys R Us space, well, maybe there's clauses in the Kohl's contracts next door that says there can't be a grocery store lease here, right? So there's use provisions that you run into. And so if there's something like that, some restrictions and easement issues, then we get into some hairy stuff with the debtor, and we can fight the assumption and the assignment to somebody. So it can get a little sticky in the assumption context, and especially in the assignment context, because in a lot of these retail cases, we'll say Stage Stores is probably a good example right now. They run Gordman's and Beals. Well, they filed bankruptcy. They're running store closing sales. They have big spaces that some folks are looking at. And these are third-party buyers. It may be a Big Lots. It may be Piggly Wiggly. They're looking to get these leases that there was a bankruptcy 2 years ago for the Gordman stores. Now some of these are on amazing rent deals. And so Piggly Wiggly might want that rent deal. But if you have use provisions in your shopping center that say, we can't have a grocery store here, get us involved, because we can block that assumption and assignment. All right, so part of the 2005 amendments to 365, during the pendency of the case, the debtor in possession, which is the company that filed, or the trustee, if it's a Chapter 7 context, must timely perform its lease obligations. And so for real property leases, the magic language is when the payments, quote unquote, arise after the bankruptcy is filed. There have been, something like 7 or 8 of the circuits have now spoken on this issue. The question is, what does arise mean? So there's the proration approach versus the billing date approach. So in our example, the Toys R Us files on June 10th. So on June 10th, when did the June payment arise? Well, June actually arose on June 1st, right? Under the lease, rent was due on June 1st. They didn't pay it, and now they filed on June 10th. Well, because payments arise after bankruptcy, is that pro rata? Do I get payment immediately from June 10th through June 30th? Or do I have to wait till the end of the case to get paid for that? So the proration approach says, no, the June 10th through June 30th, that's an administrative claim under 365D3. You should get paid for that as a landlord. The point of 365D3 is that when payments arise and to prorate the lease makes sense, right? Billing date approach says no. Plain language of the statute says when payments arise. The payments arise on the first of the month. So I'm sorry, you don't get rent for that first month. You get rent starting July 1st in the bankruptcy, right? And so it's it goes a lot of different directions, and there's some sub issues there of when is timing for payment. So Southern District of New York has actually come out and say, under this proration approach, you get paid immediately. But the Fourth Circuit has said, well, you definitely have an administrative claim, but you need to wait to get paid on that. So there's a lot of nuances there. We have a big chart, so if you have a shopping center tenant that files, we can help for that. And now a new issue that we're seeing, and I'd say for the first last 5 or 6 years, so the first 100 pre-COVID retail cases I've had, I never saw this issue raised, but 365 provides for a 68-day deferment of rent for cause. Cause in this context is difficult to reach, right? The debtor, the tenant has to prove that there's some reason why they can't pay rent, some reason why the deferment of the rent would make sense. And there's very narrow context where this could occur. COVID happened to be a context where it definitely occurred. Debtors were running into court saying, we're shut down right now, and in 60 days it might be different. We might be reopened. And so every tenant I saw that filed this motion was granted it by the court. Some courts even went beyond this with some very dubious code and case law reliance, but that's a CLE for a different day. But just know that that's out there now. It's being used. We've seen it in JCPenney. We saw it in J. Crew. We saw it in Stage stores for locations that weren't open. So something we hadn't been seeing before, but with COVID, we've been seeing quite a bit of. Personal property leases are a little bit different. Under 365 D5, lease payments that arise 60 plus days after the bankruptcy, they're required to be paid. And so your payments that are due in the 60 days prior, those are administrative claims. We haven't talked much about prior to claims, but it's very important in the bankruptcy context. Administrative claims, to confirm a plan, they have to pay them 100% on the dollar. General unsecured claims, often pennies on the dollar. You want to do everything you can to file your administrative claims timely, because that's where the money is. I think the real takeaway here is the lessor does have to be compensated for the use of its premises or equipment during the case. You will have a priority claim. If the debtor is not paying, which we will see on occasion, then your remedy is to go into court, ask for the administrative claim, but also ask the court to compel rejection of the lease. Like I said, when they reject the lease, they have to vacate the premises, they have to give the equipment back. It may take 30 days to get that motion through, but often when they see it on file, you can work something out with them. The debtor, that is. Oh, and I guess that is the end of the slideshow. We're a couple minutes over, but we're happy to answer any questions you may have. I know it was kind of drinking from a fire hose on creditor representation. And like I said, there's a lot of nuance, but we're happy to answer any specific questions you have here or on the phone later.
So we did have 2 questions by text. One's from Chris Rockers, the other one's from John Cresciani. And we'll address those real quick. Before addressing Chris's question, there's one nuance, but a relatively major nuance that I did not discuss in my half of the presentation. That is, to the extent that your contract is a loan, or as the bankruptcy code would refer to it, a financial accommodation. Under 365E, that financial accommodation cannot be enforced by the debtor against you. That is, the debtor cannot make you loan them more money once they're in bankruptcy. And I think Chris's question arises primarily out of financial accommodations. And his question is, if there's a provision in your agreement that an involuntary bankruptcy is an event of default, and it's only an event of default if the involuntary bankruptcy is not dismissed within 90 days, is that enforceable? And so certainly in the financial accommodation space, that is a credit agreement or something similar to that, those provisions I think are fairly common, and that's enforceable. You can agree to waive that default in the event that the involuntary bankruptcy is dismissed within 90 days. My suspicion is that if a similar provision is in a executory contract, which is not a financial accommodation, that irrespective of whether the filing is voluntary or involuntary, the non-debtor counterparty is not going to be able to get out of the case because the debtor ended up in a bankruptcy either voluntarily or involuntarily. So that is going to remain a void provision. John's comment was whether on the discussion regarding invoices, to the extent you've got a purchase order which requires progress payments or performance over time, that purchase order could be considered to be an executory contract if, for example, the bankruptcy is filed halfway through the fulfillment of that purchase order. So there's no black and white rules on a lot of this stuff, and so it reinforces the need to look at whatever agreements you have with a potential debtor, with somebody in the insolvency space, and we can figure out how to best address and what protections you might take, how you might try and terminate it before the bankruptcy is filed, irrespective of the financial condition of the debtor, and whether or not that's a leverage you want to try and use. Any live questions? All right, hearing none, I think we'll conclude the presentation. Thank you very much for taking some time and listening to us. Don't hesitate to reach out. We'd be glad to help out in any capacity we can.